How is everybody?
Great.
It's Friday. We love Fridays. So what's happening in the world of the law? Supreme Court is now giving lawyers 2 whole minutes to speak. Did anybody see this? Like, I just happened
I'm
to
not
see
sure
this.
how I feel about this.
You're not sure how you feel about it?
Because this is what screwed me over when I did my oral argument last
Oh, you got
semester.
too much time at the beginning, right? You got to talk for too long? Is that what screwed you up? Or you
the
got
way
interrupted immediately?
No, the way they prepped us, like when we did practice rounds,
Yeah.
was, they started asking questions really right off the bat. That was what I was prepped for. I was not prepped for like 2 minutes of a cold bench.
Well, I suspect that the way that you were prepped was to expect the unexpected. I hope so, anyway, right? So maybe they break in on you in 15 seconds and maybe they let you talk for 5 whole minutes. I don't know. I tell my lawyering skills students the worst oral argument, not the worst, but the second worst oral argument I ever had. It was one, what did you say?
I said it was mine. No, I'm kidding.
No. So me personally arguing. That's a whole different kettle of fish. But the second worst argument I ever had was just a completely cold bench, where nobody asked any questions at all for the entire 15 minutes, and you're just up there floundering, and it's like wondering if anyone is listening to you or if anybody cares. And in fact, it was totally cold for appellant's argument, appellee's argument, and rebuttal. So anyway, this is good, I think, just because you know what to expect now. You know you're going to be able to at least get your first couple of points out and in the open, and not get immediately torn into by a justice that disagrees. So it's good. The practice of peppering advocates with questions right off the bat is kind of a new one. Didn't do that before, let's say, the Rehnquist Court. That's a development that really happened while Chief Justice Rehnquist was the guy. So this is probably a step in the right direction. Anyway, back to proceeding civilly. Offers of judgment. So everybody read a very meager reading this week, but I think it's an important bit that is often overlooked in civil procedure courses and in civil procedure in practice. Because the offer of judgment is a pretty cool thing that a defendant can use to get some leverage in some litigation that they maybe don't want to take to trial. So here's the scenario. You've gotten all the way through discovery. This is the way this usually happens. You've gotten all the way through discovery, and you're getting ready to go to trial, and you're the plaintiff's counsel, and you get in the mail this offer of judgment. Right? What is an offer of judgment? Who can bottom line, who understood the language in Rule 68 and can explain it to me in plain English? Part of the reason I had to read that Smith case is because it helps put it in perspective. The language in 68 itself is not super clear. Yes?
I don't know if this is right, but it almost feels to me like they're wagering on what you're going to get at trial. And it's like a way to say, if you don't get more than this and you turn down our judgment, then you have to pay.
That is exactly it. Yeah, that is exactly it. So, defendant thinks, okay, you've gotten past summary judgment and the motion to dismiss and all the other dispositive motions and other devices that we can throw at you to short circuit your case. And despite our best efforts, we're still going to try. But I still think that your case is a dog turd, that you're not going to get any money out of a jury. And so I'm going to tender an offer of judgment. I, defense counsel, tender to plaintiff's counsel a document that says, here's an offer of judgment. It basically says, you're right. We did the bad things that you say we did in your complaint. You get a judgment. But we get to control the amount of that judgment, and the amount of that judgment is $500, $1,000, $10,000, whatever. And the wager is that if the plaintiff is not able to get more than $500 or $1,000, whatever the amount of the offer of judgment is, out of a jury, then the plaintiff is going to be on the hook for defendant's costs from that point going forward. Okay?
Can you repeat that last part?
Yeah. What? Starting from where? Okay, defendant takes, here, I'll put up the slide. Defendant tenders the offer of judgment, says, here's what we're going to give you. You win, here's what we're going to give you. Plaintiff says, no, your deal is not good enough. I think this case is worth $500,000, not $500. So we're going to roll the dice. Take it to a jury. You get a judgment, but the jury only gives you $499. A plaintiff then has to pay all the costs of trial that the defendant incurred. That make sense? Do I follow that?
So if the jury were to award more than the offer, then the plaintiff is fine.
Plaintiff is fine. Jury awards $501. You're not on the hook for all the costs. A pretty useful device. Now, when can you tender this? Put your defense hat on. Your defense counsel. When can you give the other side one of these? What does the rule say? Days before trial. Could you tender an offer of judgment to the plaintiff right after you file your answer?
Yeah.
Who says yes? Who says no? Okay. Who doesn't know? Because you didn't read the rule. It's fine. Yeah, you can tender at any time. You can tender at any time. If early on in the litigation you think, oh man, this case is a piece of crap, but who cares if our client has a judgment against them? We don't really care about that. And you might. You might just care about the face value of having a judgment against your client. That's something to consider. But if you don't care about that, and you just want to buy down the financial risk to your client, you could tender this offer of judgment, and I've had this done. Seen it done. You could tender an offer of judgment first thing in a case. Say, all right, we'll give you $10,000. Before we do any discovery, before we do anything at all. Go ahead, what's your question?
In our bar brawl case, could he do it right after you hit him on the head? Like,
Well, there's no, not before there's a case. Anytime in the litigation. But if there's no litigation, then there's no way you can tender an offer of judgment. I don't think so. I don't know. Right? So you can tender that anytime. And then you mean to tell me that if I tender an offer of judgment at the beginning of the case, that the plaintiff could be on the hook for all the costs going forward from that point on if they don't do better than the judgment that I tendered them? Yeah. That's what the rule says. But normally when we see these tenders, after most of the discovery is wrapped up and liability and defenses, how that's going to shake out at trial is pretty clear, right? And after dispositive motions are over. defendants do not want to risk having any kind of judgment against their client at all. Put your plaintiff's hat on. What do you need to consider other than the amount that you think you're going to get from a jury? What do you need to consider when you're trying to figure out whether or not you accept one of these?
Just your case, like, you know, how solid you are on, you know, everything that you can account for, and then also, kind of your your courtroom environment, like, you know, the judge, your potential jury, you know, your sympathy, and all this.
Yeah. I mean, I think that's right. Obviously, that's right. You have to figure out how good your case looks overall. Is it still possible? Let me ask you this. You survive, you're the plaintiff, you survive all the dispositive motions, the motion for summary judgments, everything else. You're going to trial. Is it still possible for your case to be short-circuited before the jury ever reaches a conclusion? Is that possible? What could happen to destroy your case before it gets to the jury?
You die.
You die, well, maybe. Yeah. Okay, but we're talking procedurally, so let's think through that. You have a witness that you know you need to make your case. The witness doesn't show up, or the witness dies, or something like that, and as a result, you can't prove key facts that you need to be able to prove at trial to be able to get a judgment. What happens to your case? Procedurally, what happens to it? Who knows? Or what could happen to it, I should say.
Dismissal for not having anybody able to.
Could be dismissed. What happens at the end of, who's done enough trial practice type stuff to know what happens at the end of the plaintiff's case? So the plaintiff puts on their case in chief at trial. Right? You go through all the motions. I've tried to prove everything that I can possibly prove in my case before I turn it over to the defense. It's true in criminal trials too. Before I turn it over to the defense and say, all right, now you put on your case in chief. But there's a very important thing that happens in between those two cases, the plaintiff's case and the defendant's case. Right? Really important. What happens? Neil.
Motion for summary judgment.
Could be a motion for somebody. That can happen at any time. That's probably already come and gone, right? Motion for summary judgment essentially says there's no genuine issue of material fact for a jury to decide at trial. Okay? So it's subtly different from what I'm talking about. Elizabeth, you
I
go.
was gonna say, but I don't know, it's the same thing, kind of like a judgment on the merits or something? I don't know.
Yeah, it's a whoever is doing the plaintiffing or prosecuting at the end of the plaintiff's case in chief is going to make a motion for directed verdict. In other words, we've heard your case. Defendant is saying, okay, we've heard your case, the jury has heard your case, and no reasonable jury could ever render a judgment in your favor. Your case, as you presented it, is not what you said it was going to be when we were briefing this on summary judgment. No reasonable jury could agree with you, plaintiff. Do you think these motions get granted? Sure they do. Sure. Yeah.
I can sense a difference between this and summary judgment, but I can't quite articulate it. Can you maybe?
We'll get there. I mean, the basic difference is, and we're getting way into summary judgment next week, so we'll talk more about it. But basic difference is that summary judgment, you're trying to determine whether there is a genuine issue of material fact to be determined at trial. Right? Once you get over that hurdle, you put your case on at trial. And then in a directed verdict standard, you're asking, can a reasonable jury find for you? Would a reasonable jury issue a judgment in your favor based on the facts you presented at trial? Okay. It's not, if you're thinking that doesn't sound super different, it's not, right?
It's more of a procedure we do.
Well, because the way, the chief difference is that the way that you present the case in summary judgment briefing, you're sort of saying, here's what we're going to present at trial, right? And so that's not actually what you present at trial. If it comes out a little different, which it often does, and a judge says, no reasonable jury can find for you based on what you presented here, right? Then that's a direct verdict. Also consider, though, with your plaintiff's hat on, what is the value of having a judgment against this defendant, right? Even if it's a small dollar judgment, there's some value in that, right? There's some value in the vindication of having a judgment. You don't get a judgment if you settle a case. 99% of all these cases get settled with confidentiality agreements and all of these other conditions that go along. There's a value in having a judgment because it's comparatively rare that you get a judgment against a wrongdoer. That's something you can hold up and say, look, I got this judgment. Smith versus State Fair. Somebody explain to me in plain English what happens in Smith versus State Fair. What's the lesson of Smith versus State Fair? I feel like you want to talk about it. You have this look in your eyes like you want to say.
Make sure that you offer the correct amount for the dues.
Well, let's make sure you offer the correct amount, because why?
You can't withdraw it. within 10 days.
Can't withdraw it. Yeah, the Kentucky rule is 10 days. Kentucky rule is 10 days. Slightly different from the federal rule, right? Rule is 10 days. And or J. Fox Camoisey tenders this offer of judgment, and then his client changes its mind, says, no, actually, we can't afford to pay that judgment. Please withdraw it. The other side looks at it and says, no, you can't withdraw it. It's got to be open for at least 10 days under the operation of the rule. And therefore, we'll take that judgment. Thank you very much. And remember, folks, this is a judgment that the other side gets. I want to emphasize that. And it comes with everything that you get when you get a judgment against a defendant. So if you try a case, you get a judgment against the defendant. It's really the same as taking one of these judgments under Rule 68. Okay? Same thing. And what does that entail? Well, it's a very big landmine that a defendant can step on in these cases. Okay? Before you go before you go hang a shingle someplace after law school and start tendering these offers of judgment, because you're like, I learned about this thing in Candace class, this sounds really cool. If you're defending a case that comes along with an award, a statutory award of attorney's fees, you need to make sure that your judgment amount includes those attorney's fees. So, in constitutional tort litigation, 1983 cases we talked about a little bit. Of course, when you take my civil rights course, you'll learn all about those. Employment cases, whistleblower cases, all those have statutory awards of attorney's fees. Now, stop for a minute and consider our battery example that we've been dealing with all semester long. In that battery case, if McCoy gets a judgment at trial against Hatfield, can McCoy then collect attorney's fees from Hatfield? Does he get his attorney's fees? He wanted trial. Right? So he won $15,000 in trial. Does he then get to go and collect $50,000 in attorney's fees from the other side? Maybe. So,
I'm not sure about the actual statute that there are specific like causes of action in
the American rule is that each side bears their own costs. Right? You're going to pay your own fees. Unless there's a statute that specifically says, in this situation, you get your attorney's fees. You're not going to collect them from the other side, even if you win a judgment. Right? And that's certainly true of almost all. I mean, I can't think of any common law action that would come with an award of attorney's fees. Right? So all the stuff that you learned about in torts class during first year, negligence torts or intentional torts, none of that stuff comes with an award of attorney's fees for the winner, unless there's a statute in that jurisdiction that specifically says you get attorney's fees in this case. And those are pretty rare. These examples, civil rights cases, constitutional cases, employment cases in Kentucky, whistleblower cases in Kentucky. Those come with attorney's fee awards. So you tender an offer of judgment. Think about how this works. Again, you're offering a judgment to the other side, to the defense, along with everything that entails. So if you tender an offer of judgment that says, all right, well, here's $5,000 for this civil rights violation, sorry about that, but that's all you get. You haven't specifically said in your offer of judgment, this includes attorney's fees, $5,000 inclusive of attorney's fees. You've malpracticed your case. Because if I'm the plaintiff, I'm like, great, I'll take that $5,000 judgment. And now, I'm going to petition the court for my attorney's fees under the statute that gives me to me. Do they follow that? Kind of make sense? Easy, right? Think you can draft one of these? An offer of judgment? Sure you can. Sure you can. Sure you can. I need to see some confidence here, folks. Call upon your resources. You're the defendant. Draft an offer of judgment that you think is going to entice the plaintiff to settle that case. Give me good formatting on this. You don't have to notice it. It's not a notice motion order. It's not a motion at all. It's an offer to the other side. Okay? It's an offer to the other side. It's not a motion. So don't worry about any of that stuff when you're formatting. Title it Offer of Judgment.
I know, I saw that too.
So are we all working